take viewers to the PI show. Just before the break, we were talking about the role of the barrister, their duties and obligations. Harry, that's what we're talking about now, what their role is.
Yeah, well look, their main duty is they're officers of the court. So you've got a duty to the court and then you've got a duty to the client. But it was highlighted in a case recently in Victoria where the Court of Appeal made adverse comments about the one barrister in a case where they had a sort of win-at-all-costs attitude and didn't have, in effect, a proper duty to the court.
Well, he didn't follow the rules and procedures that are in place.
The protocol in place.
Yeah, protocols in what questions you can and can't ask and how you sum up to a court.
Which is very important. A barrister's got certain obligations both to the court and to his client, and in particular, a barrister must take all reasonable steps to fulfil his commitments.
Well, he's there to assist the court to arrive at a decision, so he's there to facilitate. He can't waste time or...
For instance, a barrister can't be in court for 3 days running a trial. He decides to have a game of golf the next day, because he's arranged it with his mates, and say to the judge, look, I'll be back the day after next time I have a game of golf. That's not acceptable. If a barrister takes on a case, he must complete the case unless he's got a reasonable reason
to withdraw.
Well, I've seen a lot of examples of where barristers have said to the court that I've got a funeral to attend.
That's acceptable
Harry,
generally.
I've seen it quite a bit.
The court can accommodate that up to a point. Up to a point, but
certainly on a social occasion he can't.
No.
Yeah.
But in a situation like that, of course he can.
And then, Alan...
but there's a higher duty here, Harry, to the court. You know, people think that the first duty is to the client, but the biggest duty is to the court.
Yeah, they're primarily an officer of the court. They're there to really to assist the court, present evidence. They're an advocate for a client, but they're to present evidence, and they've got to do it in a timely way. They can't waste time, have unnecessary cross-examination,
unnecessary delay.
Unnecessary
but more
delays.
to the point, Harry, where I'm coming from is if they come into information that is damaging to their client, what do they do?
In some cases, they've got to return their brief. I mean, that's a drastic situation.
What if the case is running? It's been going 5 days?
Unfortunately, as you say, Tony, they owe the first duty to the court, and if they know the information that may be adverse, they must inform the court as to the situation if they've come into that information during the course of the hearing.
And then what?
Well, they must either withdraw or confer with their client with the client withdrawal.
Because, see, the barrister's also got to be careful that they don't breach the client's confidences. That's the other thing.
Indeed.
Yeah, but if the information is misleading the court, then they've got a duty to the court as well. So, look,
it's a fine line.
It's a fine line, and I think there are extreme cases, but in most cases, the barristers, I think, do a very good job.
Yep.
And they're there to...
Well, as we discussed earlier, they're under pressure. They're under pressure to present a case in a very
timely way. And sometimes they may say things that they don't mean to say, but generally they are controlled. And this is why we have junior counsel also to help senior counsel direct the way they run a case. But the barrister can't be sued for negligence. If they make errors in running a case, they can't be sued by a client for negligence.
Not whilst they're on their feet, Harry.
No, they're immune. They're immune from that.
The case that ran to the High Court was the Ginarelli case, where the Ginarellis gave evidence to a Royal Commission, and then that evidence was used in court, and the barristers didn't object to that evidence. And that evidence should have been excluded from court. They didn't object. The two of them were convicted and spent time in prison. And when the matter went to appeal, it was first time raised that the evidence shouldn't have been presented. And the Ginarellis took the view, look, the barristers didn't run the case properly. I spent time in prison, and I'm going to sue the barrister and the solicitor. And it went to the High Court. The High Court said, no.
There's an immunity.
There is an immunity. You cannot sue a barrister for any negligent conduct in a courtroom.
In running a case.
Yeah.
But that's not the case everywhere else in the world, Harry.
No, I think that's gone in England, in Canada, and other parts of the world. In Australia, it's still the law. And there was a case where someone was pleaded guilty to a rape charge at a committal. And again, he spent time in prison. On appeal, the rape charge was dismissed, and he said he was under pressure and advice by a barrister who I think was junior, and he shouldn't have pleaded, and the court said, no, you can't sue the barrister.
Well, when you're dealing with barristers and their duties and roles and what questions they can ask, I think the most important thing is that any barrister's got to put his case, his client's case, to the other witnesses. That's first and foremost.
Yeah.
Yes.
Yeah.
You've got to basically say, you know, my client or
Well,
something along
what
those
your
lines.
instructions are
Yeah,
about the merits of your case or the
And the barrister owes a duty to the client as well in advising them about the issues of the case, the success of the case, the likely success, the shortfalls of the case, and whether in fact he's going to be successful and what he's asking for is fair and reasonable.
Well, if he thinks he's going to lose, he's got to tell the client that, doesn't he?
Indeed.
advice.
He
Yeah.
does.
He can't
He does.
say, just run it for the fun of it and then collect 10 days
let's
of
see
fees.
if we're lucky.
Yeah.
And if an offer's been put on the table in the course of a hearing, he's got to advise his client of the merits of that offer and whether it's within the ballpark.
All advantages. But does the barrister have any role in negotiations, or do
Yes,
some
generally.
barristers better it than others?
Well, there's
or-
certainly some barristers are better than others. It's like some better solicitors and better PI solicitors. But in essence, the barrister has then got to negotiate with the other side's barrister. They take the role of the negotiator, if you will, and they will then banter and come maybe to a successful conclusion. If not, if they can't agree, the trial would continue.
Harry, a lot of barristers think that's a sign of weakness to negotiate heavily. That's the impression I've got.
At
over
some
the years.
stage, it's varied. Oh, look,
The barrister, at the end of the day, wants an outcome for his client.
yeah,
And if you can reach an outcome for the client
without a risk.
without a risk or limited risk, then he's going to look for that
And
option.
in your experience, was the best time to negotiate on the morning of a trial?
That's generally the most times that cases settle is on the morning of the trial.
That was traditional.
Traditional, but they've introduced mediations
They have
to try and
indeed.
stop that.
They have. Again, to reduce the question of costs.
I think it's foolhardy for a lawyer or barrister to think that the last day is the day when you get your best result.
Indeed,
These days.
these days.
And the barristers can talk amongst themselves
They can.
without prejudice,
Without prejudice,
and that can't be used
during the course of the hearing of the
in the
proceedings.
course of
And that's
hearing?
very important
It
too.
is.
because you can't say that an offer's been made when it's made in confidence.
That's right.
So,
Well, the whole system would break down. I mean, you can't say anything without it being used against you.
Yeah.
yeah, so it's without prejudice discussions,
Yeah.
the barristers.
Yeah.
And brief to counsel, what does briefs mean?
A
Does it,
brief,
you know,
brief
is-
mean doesn't mean his underpants.
No.
It
this
means
is-
papers, documentation to assist the barrister in
presenting the case. And the briefs can be voluminous.
They can be, very.
Well, Alan, look, you might have to be back by popular demand on another occasion. We
I'm
don't
happy to
know.
come back.
Alan, thanks for coming on
Thanks
board.
very
It's
much
been
for coming
very
back, and
enlightening.
it's very, very helpful. Thank you.
Yeah.
Thanks.
Thank you.
See you after the break.